Hi everyone. I am missing being with you this morning in class. I will tell you about my slip and fall on the ice when I broke my wrist, about my experience in the emergency room, on mind-altering drugs when they were realigning my wrist. So all of that interesting stuff. I'm still waiting on a surgery date, and hopefully it'll be within the next few days. And I hope to see you in person after spring break. If you have any questions about the midterm or are confused about any of the study guide questions, just reach out to me and I will be happy to jump on a phone call with you or something like that. So I am going to just pick up right where we left off in class on Friday and talk about so we're talking about privacy and what can be protected. So we were talking about that someone's image, the way they look, can be protected. The voice, the character, lookalikes, and illustrations. Sometimes if it is creative work, someone changes it in some way, it's a parody maybe, or a satire, or it's just a creative outlet, like a painting of a person, then that can be protected for privacy reasons. We talked about the Kim Kardashian example, and now I want to go to the Booth rule. This is a law that protects celebrities, public people. It refers to commercial use. So if I am wanting to cover a celebrity or cover a news person, I can still do that as a reporter. So the media can still cover individuals if it's a legitimate news or entertainment story. And they can even use the article or cover of a magazine to try to sell subscriptions. So the Booth rule is the example of that. I believe it's on page 277 in your textbook. Now, we changed editions before we started this class. And so I'm trying to remember if I do believe I went and looked up the new page number in the new edition, but I'm not positive at this moment. So if someone's trying to use someone's likeness in advertising, they cannot do that unless it's the example of the Booth rule is it was a Time magazine ad or a Time Life ad, and they were just showing different covers of their magazines when they were trying to get people to buy subscriptions. And so Booth, who was a famous person at the time, her photo was on one of those magazines that was used to sell subscriptions. And that was ruled that it is protected. It's not a privacy issue. It's not appropriation if it has been part of a news or information content. So that's kind of something that protects the media from any kind of privacy accusations if it's something that they're putting on a cover of a magazine or something like that, even if later they're using that cover in an advertisement to try to sell subscriptions. The next slide is Dr. Oz. I'm going to let you watch this video on your own. But this, of course, way back before he ran for Senate in Pennsylvania when he had his own TV show. A lot of people were using his endorsement illegally. They were saying that he had endorsed their products as a physician, a famous physician. So they were using his actual name and his likeness in their advertising to try to get people to buy certain types of products. So you can go watch that video. The link is there for you to watch and see that he sued all of these companies because they were using his image. All right, so two customers sued a doctor, or sorry, sued a dog racing track for including their photo in an advertising brochure for the facility. So the plaintiffs had viewed they were at the park often, and they were photographed when they were sitting with other people in what is called the winner's circle, which is a section of the park that can be reserved by interested groups or spectators. And so they did not have, the park itself, the dog racing track, did not have written consent for the use of their photos. But there was a lot of evidence that the park officials had told the plaintiffs that they were taking the photos, and they gave them the chance to leave if they did not want to be in the photograph. But they did nothing. They didn't object. They didn't move. And so they were given the opportunity to not be in the photos by park employees. So basically, them just staying in their seats, even after being warned, even though they didn't sign anything, that showed that they had given consent to have their photograph taken at the park. Now, this is one that was in the Alabama Supreme Court. So if you're using someone's photos in ads or brochures, things like that, consent is the best defense that you have. So you do want to get written consent if you can. So as we talked about in class, at Rochester University, you sign a consent form when you register to be a student at Rochester University, and that gives the university permission to use your photo. Also, though, if you do know that you are taking, that your photo is being taken, that is also giving consent just by your willingness to be in that photograph. The best thing for us to always do, though, is to have that model release form. And that is one of the reasons why the university has all students, gives them the opportunity to sign that or not sign that when they register at the university. And so that provides protection for the university if we're using any students' photos in marketing materials. All right. It's taken me a little while to move between slides because I am not left-handed. So, and my right hand is broken. My right wrist is broken. So, when does consent not work? If it's only oral consent, it will devalue over time. So if someone they said, oh yeah, you can take my photo, but it's been a certain amount of years, then that is probably going to devalue. It doesn't mean that you don't have protection, but it is something that is just not as strong. So if I'm going back and pulling out a photo from someone at Rochester University 10 years ago, and we don't have written consent, but oral consent, it may not hold up in court as much as a written consent. There are some people who cannot give consent at all. Those are minors. So you have to have their parents or guardians consent. Those that are mentally ill and prisoners. Another thing that consent does not protect is if you change the material substantially from when the consent is given. So there's a lot of examples of that. It could be that you Photoshop the photo, or you're changing the way, you're doing some kind of alteration to the photo, and that is changing the use of the photo from when the person gave consent. So that can also be a time when consent does not work. All right, there are 4 types of privacy law. Let me just go back up to review where we were, the 4 types. So that's appropriation, intrusion, publicity about private facts, and false light. So that was appropriation, and now we're moving on to intrusion. And this is one that we are more aware of when we talk about privacy. This is what most people commonly think of when we do talk about privacy. This is when one person or one individual violates the seclusion or solitude of another individual. And this can be done with telephoto cameras, microphones, snooping even through someone's private records. And it really focuses on how the information is gathered. And even if you don't publish the material, a plaintiff might still have a case. Never think that anything you post on the web is private. I know you've been told that 100 times, but if it's appears on the internet at all, then it is probably always going to be on the internet. Or someone could screenshot something or download a video, and even if an internet service provider takes that down, then that person who, if they did that, they can still put it back up on the internet. It's just the result of modern technology. So intrusion has a lot in common with both civil and criminal trespass. So it's not unusual for a plaintiff to sue for both trespass and intrusion in the same lawsuit. So that might be the judge or jury might just, throw one of those out or not, but they're very similar, just using different parts of the law to try to make their case. So we really talk about, Americans are right to freely speak, the right to talk about others, but we're also wanting to protect our access to and disclosure of information about our own private lives. So sometimes this can result in privacy lawsuits. It could be, at what point does the right to publish truthful information about a person give way to that person's right to be left alone? So it's kind of like a balance. We talked about, how the courts are often weighing different rights that we have and trying to balance those rights. So the first step for courts is whether the person claiming that their privacy has been violated to ask, did they have a reasonable expectation of privacy? All right, so basically the general rule is there's no privacy in public areas. So do people, including citizen journalists, you and me, running around with our phones and taking photos at a concert or wherever, do we have a First Amendment right to videotape and photograph the activities, say, of police officers performing their duties in public? It's something, we've heard a lot about this in the last decade even. There was a case even in 2011 where a man was arrested in Boston. He was on the Boston Commons, which is just like a big park area in Boston. And he was using his cell phone video camera to film several police officers that were arresting a man. And he thought they were using excessive force, and he took a video. He was standing about 10 feet away from the officers. So they arrested him, and the court ruled that his rights were violated because he was in public. He was filming in public. So the court said, gathering information about government officials in a form that can readily be disseminated to others serves a cardinal First Amendment interest in protecting and promoting the free discussion of governmental affairs. So that's just an example. If something is happening in public, you have the right to photograph it, videotape it, record it in any way. So here's a case. This is a case that I believe you will also talk about in media ethics. And it is Schaller versus Harper's Magazine. This happened in 2007. There was a soldier from Oklahoma. He was a carpentry and masonry specialist. So he was an engineer. He was killed at age 21 by a homemade bomb in Iraq. So they had a funeral for him. They had the funeral and it was a public funeral. They held it in the high school gymnasium. They invited the press to attend. Everyone who had attended the funeral could see the soldier lying on the white pillow with his, hands folded over his uniform. So the press were invited. 1,200 people attended the funeral in this high school gymnasium, including the Oklahoma governor. And Harper's Magazine ran this photo. It was months later, and it was a photo essay entitled "The Bereaved: Mourning the Dead in America and Iraq." Well, this man, his name was Brindley. His father and grandfather claimed that the photo's publication was extreme and outrageous and went beyond the bounds of decency. They said that the casket was open for friends and family, not to be gawked at or taken, or not to take photos and publish them. It wasn't for economic gain. So they sued. They alleged invasion of privacy, and they talked about their emotional distress. They sought punitive damages and more than $75,000 in actual damages. But they lost the lawsuit over the publication. The federal judge found that the public's right to see it outweighed the family's privacy. The judge wrote this: if the plaintiffs wanted to grieve in private, they should not have held a public funeral and had a section reserved for the press. So that's just an example of public versus private. And if something is in public, pretty much anyone is protected with, taking photographs, videotapes, that type of thing. Now, ethically, that's another question. And that's something that you can discuss when you get to media ethics class. I'll tell you my point of view is I do think it was ethical for the magazine to run this photo. They're talking, the whole idea is to talk about the pain and the injustice and the harm that's caused by war. And the title was Mourning the Dead. I think it helps, for me personally, I think it helps people see the consequences of war in a way that they may not see if they didn't have photos like this or photos from the battlefield, that type of thing. So that's just my opinion ethically. So if you disagree with me, I'd love to have a conversation with you about it whenever we see each other again. So, all right, some other areas of intrusion: possession of stolen property, clandestine news gathering, harassment, and trespassing. So every time the court will ask whether the subject enjoyed a reasonable expectation of privacy. So the key is determining whether an invasion of privacy took place. So how about a reporter sitting at a table in a restaurant and that they're eavesdropping on the conversation of the people at the next table? That's not committing an intrusion. If the other diners can hear the conversation, the speakers did not enjoy a reasonable expectation of privacy. However, if the reporter hides in a closet in the subject's office and listens to a conversation, that would be intrusion. So just kind of an example of, something in public, when you should have an expectation of privacy or not. Okay, possession of stolen property. This is if the press is allowed and may freely publish truthful material about matters of public significance, if it has been lawfully obtained. So if the press obtained it lawfully, now it doesn't mean that the source obtained it lawfully. So the source could be someone who actually stole the document, but they give it to the reporter. So the reporter still got it lawfully, even though they knew it was stolen and it was unlawful. But the reporter's not the one who did the stealing. So there has to be evidence that the reporter knew it was stolen when they accepted it, and there has to be some kind of demonstration that there's an interest of the highest order. Like if the government says, oh, they knew the material was stolen, but if there's a good reason for the public to have that information, then the judge or the jury will usually find that there was a bigger interest over the right to privacy. So here's a case about that. This is Pearson versus Dodd, 1969. This did not go to the Supreme Court, but it is a case that's involving a charge of invasion of privacy. So this is Connecticut Senator Thomas Dodd, and he claimed invasion of privacy against two Washington columnists. They were very well-known columnists. Their names were Drew Pearson and Jack Anderson. And they had a column that, ran in a newspaper. And I believe that they it was a weekly column, if I remember correctly. So what happened is that two of the senator's employees copied material from his file. So this is Dodd's employees, the senator's employees. They copied the material and they passed the photo copies on to two former employees of Dodd, who then gave them to Anderson. So it kind of had a little trail here where it went from the current employees to former employees, then to the columnists. So Anderson knew how the material had been obtained. He knew that someone had stolen it. And he and Drew Pearson, his partner, they wrote 6 stories that damaged Dodd's reputation and political career. And Dodd then went on to sue for invasion of privacy. The court ruled that there's no liability for intrusion could be assessed against the publisher of that material because the journalists obtained it innocently. Someone gave it to them. It wasn't like they went out and told them to steal it. So they returned the documents in usable condition. They were not originals, they were copies. The court decided that the records that were copied, consisting of letters from constituents and office documents, were not intellectual property. We'll talk more about intellectual property when we get to copyright. But so that was an example of it going against Dodd. Now here's another example. This is Bilney versus Evening Star, 1978. So John Bilney and 5 other they were basketball players at the University of Maryland. They were subjects of an article. So what happened is that it was also in the student newspaper called the Diamondback at the University of Maryland. So the articles indicated that Bilney and the other players were actually on academic probation. So they filed suit for invasion of privacy because they didn't want their grades and their academic status to be known to other people. But again, the court found that there could not be liability for intrusion against the publisher because they had obtained the material innocently. Someone handed the information to the newspaper. Okay, so that's an example of times when media are protected because someone is giving them information and they did not take it themselves. Okay, so clandestine news gathering or undercover reporting is something that can be tricky. Most journalists don't gather information through illegal intrusion, but using information gathered illegally by others is a different matter. But let me show you this next case. This is one where the press did not win. Dietman versus Time, 1971. 2 reporters for Life magazine, which was owned by Time Life, was what it was called at the time. They posed as a husband and wife. And so there was the plaintiff was a disabled veteran. He didn't have a lot of education. And he claimed that he was a doctor and that he was healing people with clay and minerals and herbs. So the Time, they ran an article on him, and it was called Crackdown on Quackery. Good headline, huh? So, and it included 2 photos of the man. One photo was taken at his home before his arrest. He was arrested on a charge of practicing medicine without a license, and the other was taken at the time of his arrest. So what happened is that Reporters for Life magazine, they worked with the DA's office in Los Angeles to investigate the doctor. The man who claimed to be a doctor. The 2 reporters posed as a couple. They went to the man's home, and they said they were sent by a friend. So this was someone who was a client of this man, and they used this person's name. So the plaintiff, the doctor in quotes, admitted them, and all 3 went into the house and into the plaintiff's den. So the man had some gadgets, and the man was photographed. Now it was a hidden camera. So one reporter had a hidden camera, and he took photos. One of the photos did appear in the Life magazine, and it showed the quack doctor with his hand on the upper portion of the female reporter's breast. He was looking at some gadgets, and he was holding what appeared to be a wand in his right hand. The story was that she said she had a lump in her breast. The man told her, the quack, told her that she had eaten some bad butter 11 years, 9 months, and 7 days prior to that time. So this conversation was transmitted by a radio transmitter that was hidden in her purse, and it was sent to a tape recorder that was in the parked automobile that was nearby. And inside the automobile was another Life magazine employee and members of the DA's office. So the man was arrested. Life ran the story, and Dietman sued, and he won. So because a homeowner should not be required to take the risk that what is heard or seen in his or her home will be transmitted by photography or recording. So it goes back to that whole the man's home is his castle kind of saying. So he did not agree for photos. He did not know photos were being taken. Well, let me say that again. He did know that some photos were being taken but he said he thought the officers could require it of him. The defendant said, so the Life people said that the plaintiff posed for pictures, and because he posed, he gave permission. But the judge found that the quack man had no business listings. His home had no official doctor sign. He did not advertise. He did not have a telephone. He made no charges. He didn't charge them a fee when he attempted to diagnose or to prescribe the herbs and the minerals. He did accept contributions, but he did not charge them for that. So they found, the jury judge found that he did have a right to privacy because he was in his own home, and for all those other factors that I just told you about. All right. Harassment. That's another area of intrusion. This is a court will give relief to someone from reporters. Now, courts almost always reject the argument that taking a photo of someone in a public place is an invasion of privacy. However, there is a fine line between taking a photo of someone and harassing someone. California has been very aggressive in the last 10 to 20 years dealing with paparazzi. And so I have a video on there for you to watch. I recommend that you watch it because, of course, California is the home of Hollywood, and a lot of celebrities live in that area, and there's a lot of paparazzi following them around and harassing them, kind of in-your-face photography. So the California law is limiting the use of telephoto lenses, enhancement devices, microphones that can pick up a conversation from several distances. And it also triples the damages that celebrities can win from paparazzi. So there's a video for you to watch on there. But one of the best examples of this, and this goes back, this is 1982, Gallela versus Onassis. Ron Gallela, he was a freelance photographer. He basically built his career on pictures of Jacqueline Onassis, who, of course, was Jacqueline Kennedy. After her husband was assassinated, she later married a Greek shipping magnate, and her name was Jacqueline Kennedy Onassis. But this Gallela person, this photographer, he followed her around. He would stake out outside her apartment in New York. He would just follow her around and harass her and her when she was with her children as well. A federal court did agree that she was a public figure, but it did say the First Amendment did not allow Gallela to harass her or to trespass to get photos of her. So they ordered him to stay 24 feet away from her and 30 feet away from her children. So he could still hang around, but he couldn't get in her face and be as close to him. So they said there is no constitutional right to assault, harass, or unceasingly shadow or distress public figures. So the court ordered him to stay that, distance away that I told you about. And he still did it, and he was found in contempt for violating the order. He promised to never take another photo of her. And as far as I know, he obeyed that promise. All right, the next one is trespassing. Media is not immune to the law. So we'll discuss this more thoroughly in Chapter 9, which is about gathering information. But basically, even though you're a journalist, you cannot trespass on private property to get a story. And the media must obey trespassing laws. Here's an example. TV, Le Mistral versus CBS, 1978. So some TV crew members, they entered a restaurant. They did not have consent. They had their cameras rolling. There was a health code violation against the restaurant. They were found guilty of trespass. So even though the restaurant was open to the public, the camera crew did not come in with intention of buying food or beverages. They were noisy. They were obtrusive. They kind of disturbed it for everyone that was in there. And the owner asked them to leave. So they cannot stay if the owner says they have to leave. Now, if they come in and buy a meal, maybe it's a different story. But the way that this crew was acting and behaving was an invasion of privacy, and it was trespassing. All right, next we're going to talk about publicity about private facts. This is publicizing embarrassing private information about an individual that is not of legitimate public concern. Now, many of us, we've become kind of used to this in both print and electronic media, and especially online, the snooping, the prying, gossip, celebrity scandals. This one has of the four actions that we're talking about with the right to privacy. This one has the least acceptance from the judiciary. The law says that everyone does have a right to be left alone. So there are certain subjects, places, actions that nobody else has business being there. But it does say that there, at some point, a person's right to privacy can give way to other important interests. So you might have the public might have a right to know about them. So it's kind of like the question, at what point does the right to publish truthful information about a person give way to that person's right to be left alone, free from embarrassment or unwanted publicity? So that's kind of a difficult question that we have. And I was going to have a discussion in class about when we have press revelations about political officials out of place. And how does that differ from public figures? Do they deserve the protection of the First Amendment? So that was a discussion we were going to have in class. So maybe we'll try to circle back to this and have this discussion in a future class. Publicity about private facts does have the most First Amendment ramifications. Everything that is allowed to be private is something else that the public doesn't get to know. And there's a big belief in the U.S. that we should have all of our information should be public. So the requirements to get into court, if publication, of course, if more than one person must see or hear the information, highly offensive to a reasonable person, and not of legitimate public concern or interest. So it's kind of gets similar to libel and defamation. Sometimes it can be hard to determine between the two. And sometimes lawyers will sue for both reasons at the same time. Let me give you, this is an example. This is Mayhall versus Dennis Stuff Incorporated, 2002. Stuff was a a magazine that liked to show women in sexual poses and was meant for mostly for men. And this woman, she was one of two young women. She was photographed. She was at a rock concert at an Indian reservation in Florida. And guess what she did? She just decided to expose her breast, and she had tattoos or body paint on her breast. And that photo was published in the magazine. And the caption was, "Their parents must be proud." So there were two women in the photograph. Um, she sued. She said the concert was on privately owned land, um, was only open to ticket holders, thus it was private. And the court said no. A concert is a public event. So it's just law. It's a matter of law and common sense that it is a public event. Here's another example. Uranga versus Federated Publications. This is an example of that public records are generally not private. So this goes back, this one gets a little complicated. 1955, police in Boise, Idaho, they arrested several men for sex acts with minors. Melvin Deer was convicted for his role in this incident, and it was called the Boys of Boise. And he wrote a statement. He was convicted, and he wrote a statement. He implicated, he gave the initials FJ, which is who was the son of a city councilman. Deer also alleged that FJ had said he had had an affair with his cousin, Fred Uranga. FJ or Uranga, neither of them were ever charged with a crime. So this is, 1955. Almost 40 years later, Idaho was considering an initiative that would have limited the rights of homosexuals. So the Idaho Statesman published an article. They went back and they published an article about the Boys of Boise investigation and about the sentiment, the anti-homosexual sentiment that was around that place at that time. And they talked about FJ, and FJ eventually committed suicide after being expelled from West Point. And a reporter had found the original handwritten statement from Deer in the court file. So the Statesman, the newspaper, published a photograph of the statement to illustrate. It was illustrated in the magazine. The article did not mention Uranga, but you could read about the allegation about him in the photograph that was used in the newspaper. Hang on, let me get to the next slide. So Uranga sued. He said the newspaper had invaded his privacy. But the trial court ruled that the First Amendment protected the newspaper from liability because the information was in court documents, and court documents are part of the court file, and it's open to the public. So the burden lies upon the government to properly maintain court files, allowing only appropriate documents to be preserved there for public viewing. So the Durst statement, it was never even used in the judicial proceeding, but the government didn't protect that document. So once it's made available to the public, then you cannot publish the press for publishing a story about it. All right, next, naming rape victims. So you'll talk about this a lot in media ethics as well. But a rape victim's name is going to be in a police report, and a police report is a public record. So legally, you can publish the rape victim's name without facing charges. However, the ethical issue is much more complicated. And most media outlets, the reputable ones, will not publish a rape victim's name. They want to protect the victim. There just seems to be, a stigma against anyone who has been raped. Women can be blamed for that when they did nothing wrong. So they're trying to protect the victim. Now, some people, on the other hand, say, well, we need to remove that stigma about being raped because it is a crime just like any other crime, and we need to treat it the same. So if we can remove that stigma, then by publishing the name and just making it equivalent to other crimes, then that would be more equitable. But that is a debate that you can have in media ethics when you get to that class. But let me give you an example. This is a Supreme Court case, Cox Broadcasting versus Cohn, 75. Cynthia Cohn, she was sexually assaulted and murdered in Georgia. She was a 17-year-old high school student. The media, of course, immediately jumped on the story and followed the proceedings. A reporter, his name was Thomas Wassel, he did receive, he went to the court clerk. It was an open court during the court proceedings. He asked for a copy of the documents, the indictment documents, and it did contain the name of the victim. So later he did, so he had her name. Later that night in a story, he said her name on the air. Her father brought a lawsuit against the station for breaking a law. In Georgia, it was illegal to broadcast the name or print the name of a rape victim. So the father sued for intrusion. But it went up to the Supreme Court, and the Supreme Court said that the Georgia law itself prohibited freedom of the press because the press obtained that name legally. So if it's a public document, the press can use that document. So they struck down the Georgia law, said it violated the Constitution. It said that the right to privacy, although important, does not take precedence over freedom of speech. So they got the information legally. They did not have any, no deceit or foul play. So when something is of a public record, the actual privacy fades in significance because it has already been made a part of the public record. All right, I'm going to try to move on. Let's see here. Courts are reluctant to put limits on the kind of information people need to receive. And the job of editors is to decide what is and isn't important. And most editors follow professional standards when they're trying to make those decisions. Of course, as I've said, anyone can say the media is not ethical. And I would ask, well, who are you talking about? Because the media could be the New York Times, or it could be some tabloid down the street, or it could be your neighbor on his blog, right? So you got to be more specific about that. But trained editors, they decide what is and isn't important, and they weigh legal and ethical issues. Here's an example. Barber versus Time, 1942. Dorothy Barber was a patient in a Kansas City hospital. She had an eating disorder. She was constantly eating, but she had no weight gain. So she was in the hospital. A photographer took a photo of her despite her protest. She said, I don't want a photo. And her parents were saying no photos, but they took a photo. The story was published in Time magazine under the title Starving Glutton. It said her doctor found that although she had eaten enough in the past year to feed a family of 10, she had lost 25 pounds. And the caption under her picture said, Insatiable Eater Barber, she eats for 10. So this was on the medicine page, and it was giving medical news kind of in lay terminology. They printed her name and address. They talked about they made a distinction between the newsworthiness of the issue itself and the lack of newsworthiness of the individual. And the court ruled that a hospital room is private. The story was offensive to a normal person. It was almost mocking her. And the second district court ruled for Barber. So a hospital room is private. All right. Is the material of legitimate public concern? Most often, legitimate public interest in a subject matter or in a plaintiff, even the person, outweighs any embarrassment the publication may have caused. So this is Sidus versus FR Publishing Company, 1940. This is in your book. It's a very celebrated case. This is a former boy genius, William Sidus. He sued the New Yorker It published a 1937 article, Where Are They Now? April Fool. So this was, after he was, well known as being this boy genius. He was a recluse. He didn't want any publicity. He was 39 now. He worked as a clerk. He wasn't a public figure. And he said that the New Yorker had invaded his privacy. But a New York appeals court disagreed. It said that regrettably or not, the misfortunes and frailties of neighbors and public figures are subjects of considerable interest and discussion to the rest of the population. So they found that there was still enough public interest that it was legitimate to publish that case. Again, legally and ethically are different measures, right? So, okay, private fax cases. The following will usually lose a private fax case. If it's a one-time public figure, someone who was well known at one time, involuntary public figure, person who encouraged publicity, a person whose action takes place in public, and any kind of story that is up, and it's factual, it's true, and it's of public concern. So 4 types of privacy law. Now we're at, let's see, I think we're getting near the end here. False light. Yes. False light here. This is a glossary term, prohibits all publications or broadcasts that falsely portray an individual in an offensive manner. There was lawsuits against the mass media for violating kind of different, common standards of good taste and being a civil person while they're trying to get legitimate news. So again, this is related to defamation as well, but this is false light. So the 2 criteria for finding false light is that it must be offensive to a reasonable person and that the publisher is at fault. So it's similar to libel, but the plaintiff doesn't have to prove any damage to the reputation. So if you unflattering portray someone in words or pictures, a person is something that they are not, then they might sue for false light, and it doesn't have quite as high of a standard as defamation. So the general rules, if you're fictionalizing a true event, buy the rights to the real story from the people that are portrayed. You see all kinds of movies and TV shows that do this. Change the names. Don't pull an unrelated photo from the morgue to use in a story. Let me see if I have that. Yes, I do. Cantrell. Okay, so here's some examples of this. Time versus Hill, 1967. 3 convicts had escaped, and they held a family hostage for 19 hours. This was 1952. So later, someone decides they want to write a book and a play about this. And so Life Magazine does a report on the play itself. The play kind of hypes up what really happened in this situation. And it talks about the, a heroic family. They're roughed up by these convicts. And the article itself, the Life Magazine article, said the play was a reenactment of what happened to the Hill family. And the Hills didn't want any publicity. They sued for invasion of privacy. The lower court upheld the false light claim, and they appealed to the Supreme Court. This is the first invasion of privacy suit heard by the Supreme Court. So that's a major impact of this case. This was 3 years after New York Times versus Sullivan. So the court holds that all plaintiffs, even in false light suits involving newsworthy issues, must prove actual malice. So they sanctioned the press for mere negligence in reporting facts, and news articles would unduly burden First Amendment freedoms. So they said that you have to, if it's still a matter of public interest, then it's something that the press can still follow through on. And this wasn't even technically the press, it was a play at this time. All right, Cantrell versus Forest City Publishing. This is a reporter for Cleveland Plain Dealer. There was a widow and the family. A man was killed in a bridge collapse. The story implied that the reporter interviewed the widow. He described her as wearing the same mask of non-expression he had seen at the husband's funeral. He interviewed the minor, and he implied that a parent was there. Cantrell sued for false light, and also said that it exaggerated the family's poverty. The Supreme Court ruled for Cantrell, citing significant misrepresentations. So they knowingly published falsehoods about the Cantrells, and they held that the reporter and the newspaper acted with actual malice. But when I end up here, I want to tell you something that's going on in the news today, if you're even still with me here. So, Duncan versus WJLA. This is Linda Duncan. A TV station was airing newscasts with a segment on treatment for genital herpes. And she's a pedestrian. She was just walking along on a busy street. So it's called B-roll. And they use this B-roll when they were talking about this treating genital herpes. Now, in the 6 p.m. broadcast, there was a full face shot of her. There was no voiceover. The reporter says for the 20 million Americans who have herpes, it's not a cure. In the edited 11 p.m. newscast, the anchor read the same words at the same time as the tape rolls with the same shot of Duncan. So you could see her face at the same time when they talk about the 20 million Americans with herpes. So the court said the 6 p.m. newscast, that dismissed that, but it did say that the 11 p.m. newscast could proceed. And they they found that this juxtaposition of the film and the voiceover supported an inference that Duncan had the disease. So it is a need to match pictures and stories. So if you are using generic or unrelated shots to illustrate a point in a story, make sure you can identify the person, or make sure that the photo is truthful about whatever the subject is that you're talking about. Many and most false light suits involve editing or writing errors or errors in judgment, such as this case where they showed this woman's face when they were talking about people suffering from herpes. So remember, what happens in public is public. Is there a reasonable expectation of privacy? If it's public records, it will not be considered private. Unlike with libel, truth by itself is not a defense to a private facts invasion. So it's talking about the public interest as well, and newsworthiness. If a person consents to your publishing otherwise private information, they cannot claim later that you've invaded their privacy, but it's better to get their consent in writing. Okay, so we already did the Citizen4 and the privacy workshop we did on the very first day of class, so we have done all of that. There is a defamation case happening right now between Dominion Voting Systems and Fox News. It's a very interesting case, and they are talking about actual malice. So when we get back together, I'll try to just give you the highlights of that case because it's something that's happening right now that I want you to know about. All right, thanks for listening. Sorry I'm not there to see you in person. If you have any questions about the midterm or the study guide, just let me know. Thank you.